All right, Judge. Gail's sixth amended petition is defective in.
You need to share screen?
No, I'm fine, Judge. Something had popped up about live streaming, so I just clicked.
Yeah, we're live streaming this.
Okay. Gail's sixth amended petition is defective in 6 of its alleged causes of action. The defect is the improper reliance on Texas Family Code section 9.011B. Gail is seeking to use that provision to hold Cliff liable for the alleged breach of fiduciary duties arising out of their divorce decree. Gail is claiming that after the entry of the divorce decree, the company did not pay Gail appropriately, did not disclose to her information it was required to, and that Cliff is responsible for all of this. But that provision only applies to a fact scenario where one spouse has property and is required under the divorce decree to turn it over to the other spouse. That is not what is happening here. Gail is not accusing Cliff of having property which he did not turn over to her under the divorce decree, even though the divorce decree required him to do so. All of her allegations concern conduct of the company, not Cliff. Gail is claiming that the company did not pay her properly, and she is claiming that the company did not provide her with the required information. Gail inappropriate reliance on section 9.001B means that she must have those provisions of her petition struck. She can no longer amend her petition because the time for amendment has passed. The only other alternative is for those provisions in the petition that are defective to be struck. Gail's current live pleading is her sixth amended petition. That is our Exhibit A. Gail's sixth amended petition alleges 12 causes of action, as you can see in our slide 1. Amanda?
I will need permission to share my screen, please.
Yeah, you have permission.
Thank you.
We need to go to the first slide.
Sorry, guys. It crashed.
It's okay.
Anybody know any lawyer jokes?
Sorry, the PowerPoint crashed for some reason.
I don't really tell
That's-
lawyer jokes. I don't think they're funny.
Yeah.
Anybody know any judge jokes?
Hey, wait a minute. Hey, wait a minute.
Just want to see if you're listening.
Always listening.
Hey, Amanda, are we close? I can just move on.
Go ahead and move on.
Okay. So Gail's sixth amended petition alleges 12 causes of action or remedies. In her sixth amended petition, Gail alleges that Cliff violated fiduciary duties established by the divorce decree in 6 causes of action. That would be our second slide. The statutory basis that Gail cites and relies on for her breach of fiduciary duties allegations in her sixth amended petition is section 9.001B of the Family Code. And that provision says that the subsequent actual receipt by the non-owning party of property awarded to the owner in a decree of divorce or annulment creates a fiduciary obligation in favor of the owner and imposes a constructive trust on the property for the benefit of the owner. In their sixth amended petition, Gail claims, among other things, that she was paid incorrectly from the company in that she did not receive the right amount of salary or bonuses or commissions and shareholder distributions, and was not provided the necessary information which the company was obligated to give her. She relies on Section 9.011B, claiming that Cliff had a fiduciary duty arising under the decree, which he breached. Now, special exceptions are the mechanism provided for in the rules under which a defendant may question the legal and factual defects in a plaintiff's petition, such as legal sufficiency of a plaintiff's petition, the failure to be sufficiently specific, or the failure to allege a cause of action recognized under Texas law. Rule 91 governs special exceptions and provides that a special exception shall not only point out the particular pleading accepted to, but it shall point out intelligibly and with particularity the defect, omission, obscurity, duplicity, generality, or other insufficiency in the allegations in the pleading accepted to. Essentially, Rule 91 requires that for a special exception to withstand judicial scrutiny, it must be specific enough to notify the opposing party of the defect being complained of. Special exceptions must be specific and particular. Special exceptions that are too vague are considered to be general demurrers and are prohibited. In ruling on special exceptions, the courts liberally construe the pleadings in favor of the pleader and accept as true all of the material allegations and factual statements reasonably inferred from the factual statements. When special exceptions are sustained, the pleader has two choices: amend the pleading or refuse to amend and appeal the ruling. If the pleader refuses to amend her pleading, the trial court is entitled to strike the objectionable portion of the pleading. Gale's reliance on Rule 9 on Family Code Section 9.011B is misplaced. In order for that provision to apply, the property has to have been held by one spouse and awarded to the other spouse in the decree. It must have been in Cliff's possession and then ordered by the divorce decree to be given to Gale. It is the obligation of the owning spouse to turn over property to the other spouse, which is the formal fiduciary obligation. But that's not what is going on here. Gale is not complaining that Cliff owned or was awarded property under the divorce decree, which he is required to turn over to her under Code Section 9.011B. Instead, Gale is claiming that the company owed her money and information, but that Cliff is liable. Because the payment of money and turnover of information that Gale is complaining about comes from the company and not from Cliff post-entry of the divorce decree, Section 9.011B does not apply to create a fiduciary obligation owed by Cliff to Gale for the money information Gale claims is owed to her. Even if
Mr. Roberts, I mean,
Yes.
he owned he was one of the owners of the company though, right?
Well, he owns 50% of the company with Gale, but
Right.
he isn't the one who's supposed to pay Gale her commissions. It's the company that is supposed to pay Gale the commissions. The divorce decree doesn't say to Cliff, you have this money, now you give it to Gale. That's not what that has to happen for Section 9.011B to be implicated. Even if this court liberally construes the Sixth Amended Petition in favor of Gale and accepts as true all of the material allegations and factual statements reasonably inferred from the statements in the Sixth Amended Petition, which this court is required to do, the analytical conclusion is no different. There is plenty of case law on this subject, Judge, and we cite it in our petition. There's the Peikelin case, where the wife had a fiduciary obligation to turn over to her husband a portion of her retirement checks, and because she did not immediately forward them to him, she breached her fiduciary duty. There's the Ishii case, where the husband, as an assignee, had a fiduciary duty to remit to the wife her percentage of the amount of income, loss, or distributions he actually received from the businesses identified in the divorce decree. Again, nothing like this is going on in our case. As a result, Gail's claims for breach of fiduciary duty under section 9.011B must be struck. Now, Gail's response to our special exceptions has three arguments. Number one, the special exceptions are unclear as to what portions of the sixth amended petition are implicated by Rule 9.011B. Number two, that provision does not apply because Cliff allegedly exercised dominion over the company. And three, the special exceptions are a disguised summary judgment motion. All of those arguments lack merit. Judge, we sent you a notebook. I hope you got it. Because if you look at our Exhibit C to the special exceptions, you will see a chart that categorically shows every single allegation in the sixth amended complaint where Gail is complaining about these new breaches of fiduciary duty and the implication of 9.011B. So there goes that argument. Second, the dominion argument lacks merit because Gail is unable to point to a specific property under the divorce decree where Cliff is required to turn it over to her. There is no allegation here of alter ego. Third, a summary judgment motion asks the court to apply the law to the undisputed facts. The special exceptions don't do that. The special exceptions are pointing out the legal deficiency of the petition in its inappropriate invocation of section 9.011B. In conclusion, Judge, Gail's incorrect reliance on the application.
So I just want to make sure I understand your argument here, which is you're not taking a position that this claim should be heard by the family court. You're just saying this claim doesn't exist at all.
I'm saying for the purposes of this motion that this claim does not exist at all.
Okay.
In conclusion, Gail's incorrect reliance and application of section 9.011B is obvious. What this court must do as a result of Gail's incorrect reliance on this provision is equally obvious. Those provisions in the sixth amended petition that rely on section 9.011B must be struck because those causes of action don't exist here. Now, they filed an objection, Judge, and I asked that objection be struck. The special exceptions were filed on July 18th. The notice of hearing was filed on July 20th. The deadline to file a response or objection to the special objections under local rule 2.09, which is 3 business days before the hearing, was September 7th. Rhonda Pinson, your courtroom deputy, sent out the Zoom link to today's hearing at 1:51 p.m. on October 8th. And Gail filed her response to the special exceptions at 3:41 p.m. on that day. Gail missed the deadline to respond to or object to the special exceptions. The only reason why they filed their special exceptions is because Rhonda Pinson reminded them with her circulation of the Zoom link. Let's not forget that Gail has a tragic history here of missing deadlines in this case since her current law firm filed their notice of appearance on November 18th of 2021. They had 74 days to participate in fact discovery, but they never sent out a single written discovery request. They had 74 days to designate expert witnesses for the issues where Gail has the burden of proof, but they never designated a single expert witness. They had 102 days to designate expert witnesses on the issues that Gail did not have the burden of proof on. They did not designate any expert witnesses. They had 116 days to designate rebuttal expert witnesses, and they did not designate a single rebuttal expert witness. They had until March 1st to file exceptions to the court-appointed auditor's report, and they blew by that order. They blew by that deadline. Judge, this is another example of a deadline missed by Gail Fisher. Her objections to our special exceptions must be struck.
Response?
Sure, Your Honor. I'll start with the last thing that Mr. Roberts was discussing with respect to the filing of the response. If you look to Rule 4, the computation of time, under the Texas Rules of Civil Procedure, the last day of the period so computed is to be included. That includes the date, 3 business days prior. That means that the 8th was timely as to the filing. Therefore, we timely filed the response to the special exceptions. Turning to the merits of the special exceptions, you just heard approximately 19 minutes worth of merits-based arguments as to Gail's allegations as they pertain to 9.011B. The fact of the matter is, with respect to special exceptions, the only thing that special exceptions are to be used for is to see that the fair notice requirements of pleadings have been met. Here, because Mr. Roberts is able to discuss the contours of Gail's allegation in gross detail for 19 minutes plus, it's clear that that standard is met. As other courts have said, if by examining the pleadings alone, a party may ascertain with reasonable certainty the elements of a cause of action and the relief sought, the pleading is sufficient. There are other devices, of course, under the rules of civil procedure, in order to attain the kind of merits-based relief that Mr. Roberts is seeking. For instance, as mentioned in the response, there's a motion for summary judgment, which this is clearly an end run around the summary judgment procedure. Additionally, there's Rule 91A with its attendant timelines and requirements. That allows
let me ask this: the cases that were cited to by Mr. Roberts, so this is directed to really to both of you, were those cases where claims were dismissed in special exceptions, or what was the procedural?
I believe they were. I don't know that they were special exceptions, Judge.
I don't believe they were, Your Honor. I don't believe those are special exceptions cases, but I concur with Mr. Roberts. I'm not 100% aware. We can pull them up if you'd like.
Yeah, why don't you pull them up?
Okay. Let's see. I'm on Pelucan right now.
Go ahead and share screen it.
Sure. Can you say that, Your Honor?
Yeah. Let me see.
Tell me when you'd like me to scroll down. It looks like this is an abuse of discretion review after a trial court's property division, so it's not a special exception.
Okay, how about the other one?
Okay. This is an appeal from a final judgment.
From a jury trial, it looks like.
So neither of them are special exceptions.
I mean, I will say this. I do kind of agree with you that this is probably the wrong procedural mechanism. I do feel like you're kind of trying to fit a square peg into a round hole on this, but, you know, that's something that can be fleshed out in a summary judgment. I'd urge you to really take a look at whether or not, I mean, Mr. Lynn promised when he first got involved in this case that he was going to hone this case down into a reasonable level and so he can get ready to try. And I feel like there's been some things that have been done in that direction and other things that haven't. And this is probably something you should take a serious look at before we go through the lengthy and expensive proposition of summary judgments. But I tend to agree with Mr. Gardner that this just isn't the appropriate procedure for this, is to try to do this through a special exception. And I will tell you, just for future reference, on situations like this where it's kind of a close call whether or not there's really a cause of action, unless it's a situation like if somebody pleads negligent infliction of emotional distress. Sorry, I can't speak today. That's something that Supreme Court has found clearly is not an available cause of action. Then that would be probably appropriate in a special exception. I tend to think that in situations like this where it's a much closer call, that summary judgment is usually the more appropriate remedy or procedural mechanism to try to pursue this. So I'm going to go ahead and deny the special exceptions at this point. Anything else today? Do you guys?
Yes, Your Honor. This is Mike Lynn. Can I speak for 1 moment, please?
Sure.
Your Honor, I just want to give you a heads up on a couple of things that are coming up.
Okay.
What's the trial date on this? November 29th, 27th, something like that.
29th.
Yeah, 29th. I have on December 1, I finally got scheduled to have a what do they call it? A revision of my right knee. They're taking my knee apart and putting new steel in it, new titanium in it. So
Okay.
I don't think that, and I struggled to get an earlier operating time, and it didn't work out. The other thing is on November 7th, I'm going to trial in Midland for 2 or 3 weeks. And it's unlikely, therefore, given where we are on discovery in this case. Remember I don't know if you know this, but we have issued most of our discovery out of the family court. And Seymour's in the process of producing a whole bunch of documents that we think we might need. And in addition to that, we have depositions that will be scheduled for the next 2 months on basically related to some of the issues in this case and the contempt in the family court. Also later today or early tomorrow morning, you're going to receive a motion to abate this case. And the reason we're abating it is the key issue that there seems to be dispute on is the issue of what does distribution mean in the family court. As you know, our argument is that distribution, which is modified by the pronoun any distribution, meaning any character of distribution, means all money that came in to Cliff or needs to be divided it by 2 and half of it sent to us. They are saying that no, distribution means stock distributions or money off of stock. We say that's not what the family court intended. So we're going back for motion for clarification for the court in the family court, and we're going to be asking the family court to give us a ruling on distribution so that we can carry that over to this case, because we think that there's no question that the evidence will show that Cliff has not given us half of all distributions. He has had other distributions, and he's made a fortune off of this company, and he's essentially frozen out Gail. So I realize there'll be a dispute over this.
He's only gotten $22 million since the divorce.
Well, whether or not it's 22 million or 100 million, it doesn't matter.
It's 22. It's not 100.
Please let me speak. The rule is, Your Honor, that the DOD, the decree of divorce, says she gets half of all distributions. So any dollar that went to him has to be.
That is not what the
Guys, let me just say this, that I'm not ruling on any of this right now.
I know, I'm
you're
just
trying to give me an update. So you're going to follow motion to abate. What else did you want to say, Mr. Lynn?
All I wanted to do was give you a heads up that this is what's occurring. one of
Well,
the,
Judge,
I know there was a long litany of things that they say or suggested that we should have done earlier. For the most part, we couldn't do those things because there couldn't be any discovery of anybody. We couldn't get discovery out of this court. So therefore, for 8 months, we've been frozen in place with no discovery.
Why couldn't you? I don't remember.
You ruled that we had that there was no discovery permitted in this case from February until the trial. And so we were unable to.
Because it's past the deadline.
And so as a result, we asked for modification of a pretrial scheduling order. Your Honor didn't give it to us. So we had to go to the family court. The family court's given us that discovery. So we're in the process of getting the discovery. So we're not bothering you about that or pestering you about that. And we think that that's basically some of the same issues. There are obviously differences, but the main issue in the family court is whether we can hold Cliff in contempt of court for violation of a variety of orders.
Your Honor, this is not bring your dirty laundry to court, because Gail has more dirty laundry than Cliff. But I will say this, the divorce decree distinguishes, it does say that they have to have equal distributions, but in other parts of the decree, it talks about the division of stock and employment compensation. And it's ridiculous to think that because Cliff works full-time, that Gail should receive a full-time salary because it says so in the decree, and it doesn't say that.
And Larry's entitled to that argument, and we've made our argument. I think when you get it, you'll see.
Guys, I understand you guys want to fight with each other. Let me just kind of go through this real quick. On the issue of, I guess you're asking kind of for continuance. I talked to Mr. Friedman about that. I'm not necessarily opposed, but we'd like to know, sooner rather than later about that if you do need a continuance, because we're kind of anticipating trying this. My trial docket is extremely tight, and so if you move it from this date, there's a good chance you're not going to be able to try this for quite some time. And so just you guys talk that out and kind of come up with a solution. And if I can accommodate it, I'm happy to do so.
Thank you, Your Honor.
Judge, can I?
Whoa, I wasn't finished, guys. Let me finish. I listened to y'all. Let me finish. Second thing on the motion to abate, I'm not ruling on it, but I do want to kind of give you an advisory thought on it, which is based on what you said, there's almost no chance I would grant that. That being said, I'm not opposed if the family court judge wants to abate my case. You can, bring the record to, I'm not opposed to that if she feels that that is something that would be useful for the determination, if that determination needs to be made before we go forward. She's the expert on the family code. I'm not. So if she feels that some, clarification is needed or whatever, and that I should abate my case, I'm not opposed to that. She doesn't feel like my case needs to be abated. I'm not inclined at all to abate it myself. And then you said there's a third issue. Now I've forgotten. Those are the two main ones.
That's sufficient. I didn't mean to create an argument. I just wanted to let everybody know where we're headed. I don't think the November setting is going to work. I have a medical issue, and I also have as to the abatement issue, and ask the court to consider that when it's filed, because it really is, how do you heard Mr. Friedman quite logically argue that distribution means one thing. I've argued it means another thing. The only person who can really interpret that is the family court.
I'm not necessarily disagreeing with you, but I think if you can convince the family judge that it needs to be an abatement of my case, I've said it on the record. I'm not opposed to that, but I want her to make that determination. I don't feel it's appropriate for me.
And we may be able to get it.
Judge, if I could.
Wait. So the continuance issue, I think you guys need to talk out and follow motion, if whatever you want to do. I do agree with Mr. Lynn. If he has a medical issue, I want to accommodate that, but also how do we accommodate it? I know there's going to be a lot of issues. I'm glad you brought this up before the last day, since our trial docket's always busy, and since COVID, it's been impossibly busy. We're in trial every week, and it's pretty brutal right now. So you guys just need to try to talk about that and figure out if there's some type of, some dates that would work for everybody. And if I can fit it in, I'll do everything I can. Mr. Roberts,
Judge-
Mr. Roberts speak.
Let me just, Judge,
Whoa,
let me
whoa,
just
whoa,
say,
Mr. Roberts, fit. Go.
Judge, let me say a couple of things. I hope Mr. Lynn remembers that we just filed a motion to abate and he objected to it. He had every opportunity to abate this case and he steadfastly refused to abate it. Now, all of a sudden, he wants to abate the case. Number two, what I heard Mr. Lynn say was he couldn't get discovery in our case, in this case, so he's going to get discovery in the family law case and use it in our case. So he's going to try and go in through the back door when he couldn't go in through the front door. And I can assure this court that we're going to file sufficient pleadings to eliminate out and to exclude the possibility of Mr. Lynn trying to use discovery in your case, but he couldn't get it in your case. Those are the two things I wanted to point
Okay.
out.
All right. Well, we'll deal with that when it comes up.
Just wanna
Anything
make-
else, guys, before I let you go?
Yes,
Nothing here.
I want to make a short comment.
Okay.
Number one, we've been fighting to get to trial for a long time. And, because Mrs. Fisher changed counsel, you were gracious enough to give them some additional time. It's really unfair to Mr. Fisher to move this trial one more time. Now, having said that, we are very sympathetic to Mr. Lynn's medical condition. And I would just ask him to see if he could have his surgery scheduled earlier than the day before this trial. The other thing that I want to mention is Gail Fisher filed this lawsuit, if you remember, because she said the issues were different in this case than they were in the family law case. And then Gail Fisher went to the Court of Appeals to have the Court of Appeals sort that out. And then the Court of Appeals said, no, you're going to try these issues in this court and those issues in that court. But now with her new lawyers, they've brought some of the family court issues into your court. So we're back where we started.
I recognize the irony in that, but we are where we are. So you guys talk about it, see what you can work out. If you can't work it out, bring it to me and we'll see what we can do. How long is the recovery time for this surgery? Do you have any idea, Mr. Lynn?
I think I do, since I've had both knees replaced once before, and this is just a failure of one of those. Mm-hmm. So my guess is that it takes about 3 months to get back to where you basically are more or less like three. But it takes 2 weeks to basically get so you can sort of walk around the house. So that gives you a range. It takes a year before I can go back out on the Appalachian Trail. So
we're not going to get to that point, I don't think.
I'm just saying that if Mr. Lynn comes to try this case with crutches, so will I.
That would be interesting. All right, guys. Great seeing you. Mr. Gardner, go ahead and get me an order on the special exceptions. Everyone else, I hope you have a wonderful day. And we will see you, I'm sure, very soon.
Thank you, Judge Hoffman. Seymour, I'll copy you on that order.
And make sure the order says at the beginning, this was heard on September 12, 2022. You share a copy of the order with Mr. Roberts and you email the original or email Rhonda